803-442-4551, and we're going to go ahead and go to the phones and go to Jim. Jim, you're on Law Call.
Yes, sir. Thank you for taking my call. I have 6 felony drug possession charges, 4 from Georgia, 2 from South Carolina from several years ago, all felony. I've completed my sentence, paid all my fines, everything's completely been finished in that regard. I'm now a ministry leader in my church and have resolved all those issues. And I'm hoping to apply for a pardon, and I was wondering if you could help me with any advice about how to go about that, and what do you feel my chances are of actually getting a pardon?
Brian?
Well, Jim, that's a tough question. We have to look to see what your exact charges are. You said they were several years ago. How long ago were these charges? Now, it's wonderful that you're now a minister in your church. That in itself may not be enough for the pardon board. It may have to take a bit more time for you to actually receive that pardon. Again, and the pardon doesn't come off your record. The charges would still be on your record, though your record would state that charge was pardoned. Vic, how would it be handled in Georgia?
Well, Georgia would be a little different. You have certain time periods, 5 to 10 years. You can get expungements after a certain period of time. You have to go through a special procedure where you apply to the Sheriff's Department, local district attorney's office for consent to the expungement. There's an application that you can make to the Board of Pardons and Paroles for clemency, and there's an application you can make to the governor for a pardon. But those are opportunities that you have to clean up your record that you'll have to wait a little while longer, at least 5 to 10 years after the completion of the last probationary period in Georgia.
Don't tell him 5 to 10 years. you might have a flashback.
That's right.
No, I hope everything works out for you, Jim. Thank you for the call. Let's go next to Chanel in North Augusta. Chanel, you're on Law Call.
Hi. My question is, recently, a couple of weeks ago, me and some friends were at a bar, and there was a bar and grill. There was an undercover officer there as well. He wasn't an undercover officer. He was just a captain. With that being said, we were just there having a good time, having some drinks. We weren't too loud. The management didn't come up to us. The bartender didn't come up to us, but he did. And he said that we had said some words that he didn't appreciate, so he called the crew of leaders in, well, the other police officers in, and they gave me a ticket for disorderly conduct, and I was in a public place at a bar and grill. And I just wanted to know, with them giving me the ticket of disorderly conduct, is that legal? I mean, I was placed, and I wasn't being disorderly. I wasn't causing an IRAT issue or a complaint. I mean, I wasn't causing any confusion. So I just want to know, is that against the law for me to be at a bar and grill with friends and family members and then enjoying ourselves without causing any conflict?
Brian, you want to go first?
Thanks, Vic.
Yeah.
Chanel, disorderly conduct is one of the most open-ended laws that we have in South Carolina. You'd be surprised that a lot of things that many of us do all the time technically could fall under disorderly conduct. I tend to agree with you. It looks like they were just trying to come up with a reason to get you out of the bar, and they certainly could have done it better without writing a ticket. Technically, using profane language at a place like a bar where it could be overheard by other people, within the statute, it probably is a per se violation of the law. However, I would definitely recommend you going to talk to someone in South Carolina that does criminal law and go over the details of the case more closely.
Yeah, is that something disorderly needs to be taken serious because it's still on your record, right?
It is, and it's really tough because, like Brian said, the statute's written so broadly. Basically, if you engage in loud and opprobrious language in a public setting, they could charge you with disorderly conduct. Whether or not it's sufficient to result in a criminal conviction is going to be determined by either a judge or a jury.
There you go. Hope that answered your question, Chanel. I tell you what, we've got a little bit of time. We're going to try to squeeze Frank and Aiken in.